Right, moving on to the global north, we would very happy to welcome Ms. Dilber Devitre, accomplished international arbitration lawyer, currently practicing as an associate at Hamburger in Switzerland. A French qualified lawyer of Indian nationality, Ms. Devitre specializes both in commercial and investment arbitration and has served as a secretary to arbitral tribunals in numerous high-stake proceedings. She advises clients under major institutional frameworks, including ICC, UNCITRAL, and Swiss Chambers Arbitration Institution rules. With academic credentials from the University of Paris, Pantheon-Sorbonne, Sciences Po Paris, and Columbia Law School, she brings a rich blend of global legal insights. We are honored to welcome Ms. Dilber Devitre to share her perspective on the ADR landscape in Switzerland and to contribute to the depth of today's discussion. Uh, it's over to you.
Thank you so much. I had shared a presentation. Perfect. So it's on the screen. Everyone can see it. So good morning, everybody. As Imber just said, it's very early here in Switzerland, but it's still a pleasure to start this day with all of you. I'm just going to give you a broad overview of arbitration in Switzerland, and I was asked to share, as mentioned earlier, sort of the success story and what lessons can be learned. But I just want to say right from the outset that I'm happy to share the landscape about arbitration in Switzerland, but I don't think that we can take any one country's success story and apply it per se to another country. So we would discuss, and we have to see what fits within the context of the global north and the global south as being discussed within this conference. But before we get into those discussions, let's just look at what's happened in Switzerland and why Switzerland is where it is today and why it is such a popular choice of as an arbitration destination and otherwise. So I just started off this presentation with a few statistics just to show you where Switzerland lies today in the arbitration landscape. Most of these statistics are based on the statistics that have been published by the ICC and the Swiss Arbitration Center. As you can see, Switzerland has consistently been, my chart starts in 2005, but I think it also predates this, consistently been one of the top choices as a seat for arbitration. So Switzerland is the big red line there. You see that, just seems to follow the global trend, but always been amongst the top 5 choices. Same if we move to the next slide for Swiss law, which is one of the most commonly applicable civil law choices in international arbitration cases. And we look a bit later why. But Swiss law is also very consistently chosen by parties as the applicable law to their proceedings. Swiss arbitrators also have seemed to enjoy a lot of popularity. If we go to the next slide, they're always amongst 3 top nationalities, again, as per the statistics of the ICC. So the question really, I guess, that we are going to look at today in this presentation is why? What makes Switzerland such a popular choice in all these aspects? To begin with, I think, if we move to the next slide, I'm not here to give any geographical lessons, but everybody knows that Switzerland is found in the heart of Europe. It's at the crossroads of Europe. It is not a part of the EU, which also gives it a unique legal distinction from EU states. For example, I'm sure a lot of you all have heard about the recent EU decisions, particularly investment arbitration, like Achmea and Fomstroy, etc., which seem to put into question the validity of investment arbitration clauses in intra-EU PITs. For example, those sort of considerations would not apply if an arbitration was seated in Switzerland, because Switzerland is not in the EU. But at the same time, it benefits from very favorable bilateral treaties with the EU. It is party to numerous international conventions, of course, the New York Convention, a lot of other conventions, all the conventions on international arbitration. So so it's got this unique position within geographically situated within the EU, but not part of the European Union legally. And one of the reasons, one of the real fundamental pillars of Swiss arbitration law, and I think a huge reason of why Switzerland is so popular and such a sought after arbitration destination, lies in the core of Swiss arbitration law, which is the Swiss International Arbitration Law, which is the equivalent, I'd say, of the 1996 Indian Arbitration Act. This is the act that sets out the basis and the fundamental principles of arbitration in Switzerland. And if you look at this act, the first thing that would strike you about this act is its brevity. The Swiss Private International Law, actually, it's only Chapter 12 of this act that deals with arbitration. And Chapter 12 of this, or international arbitration, I should say. Chapter 12 of this act is only, up to 2021, it was only 18 articles. That is it. That's it. It like fits into 2 pages of a PDF. The center of this entire act is party autonomy. So if you read the act, almost every sentence would start with, unless the parties have otherwise agreed, blah, blah, blah. So it's just default rules in the absence of another agreement by the parties. So party autonomy is hugely important to arbitration in Switzerland. It forms the basis of this. Of course, at the same time, you have all the other common, generally applicable principles of arbitration. You have competence, which is very strictly applied. The tribunal will be the first one to decide on its own competence, except in exceptional circumstances, of course, where, for example, a party invokes the complete invalidity or absence of an arbitration clause. Broad arbitrability applications. So any private dispute, including involving a financial dispute, can be resolved by arbitration in Switzerland. In a recent amendment to the Swiss Arbitration Act, which happened in 2021, which I will speak a little bit about, now even validity of arbitration clauses found in unilateral legal documents like wills or trust documents or bylaws of companies, etc., are valid under Swiss law. So this also extends the scope of arbitrability of disputes in Switzerland. Strong protection, of course, of due process, right to be heard, and equal treatment of the parties, which really form the most extensive, I would say, framework within which any arbitration has to be conducted. Those are the outer limits, and within those outer limits, the parties are entirely free to conduct and decide on their arbitration proceedings as they wish. Something else we'll also talk about more is there is very, very minimal intervention by the courts, also during the arbitration proceedings, but at the review stage as well. All arbitration annulment proceedings are made directly to the Swiss Federal Tribunal, which is only one court. There are no several instances of appeal against an arbitral award in Switzerland. And we will see how that significantly expedites the annulment process. As I mentioned, there was a very light review of this Private International Law Act that was undertaken in 2021. And the only reason this was done, actually, or not only, but one of the reasons it was done is to make this act more readable and accessible to foreign arbitration practitioners. So all the case law that had evolved over the years, which was, of course, found in the case law, was then put specifically into the Act in 2021. So it became more clear to foreign arbitration practitioners who may have not been so well versed with the jurisprudence of the Swiss Federal Tribunal on the rules applicable to international arbitration in Switzerland. So one feature that was added during this 2021 amendment is also now the ability to make challenges to the Swiss Federal Supreme Court in English. So earlier it had to be in one of the local Swiss languages, which is the four official Swiss languages. Now this can also be done in English, which is a huge benefit to foreign arbitration practitioners who can draft the the appeal proceedings in English. So, just to summarize, as I said, this extremely pro-arbitration friendly stance of Switzerland is found in 18 or now 21 articles of the private international law. Compare that to the amount of articles you have in the Indian Arbitration Act, IMCITRAL, even the Model Law, or the English Arbitration Act. I think, that is also something that's very Swiss, the brevity and being able to put in the essence of what is needed into a very brief document. Just quickly again, the next slide, as I already mentioned, we can get the full slide on the screen if you could just click again to get the other, all of them. As I already mentioned, one key feature of arbitration in Switzerland, if the seat is in Switzerland, annulment proceedings will be made directly to the Swiss Federal Tribunal. You don't have to go to the district courts, you don't have to then go to the appellate court, you go straight, there's only one instance for setting aside proceedings directly to the Swiss Federal Tribunal. The Swiss Federal Tribunal is very pro-arbitration, but at the same time, it's a very, very good balance between pro-arbitration and reasoned, sensible decisions, also preserving the integrity and efficiency of arbitration. So as I said, always within the framework of due process, equal treatment, right to be heard of the parties. Within this framework, there are very low chances of getting an award annulled in Switzerland. As I put on the screen here, up to date, if you analyze, about 7% chances of successful annulments. And those were really egregious cases where everyone agreed that the award did need to be annulled. So a very good system of checks and balances while preserving party autonomy and efficiency of arbitral awards. The median duration of proceedings before the Swiss Federal Tribunal is 6 months. So you have your arbitral award. Let's say one party loses and wants to take it to the Swiss Federal Tribunal, a decision which again is never made likely, at least when these proceedings come to us. We clearly inform the client of the chances of success because they're so low. You really need a good cause to annul a decision. Within 6 months or so, average, some cases take longer, maximum maybe a year, you have a decision on your annulment. So you're not spending another 5 years on your annulment proceedings after your entire arbitration process. I think that's So to conclude, I've spoken about the Arbitration Act, I've spoken about how proceedings are conducted in Switzerland. Just to give a summary of all of this, based on my experience, arbitration proceedings in Switzerland are really a good blend, or take sort of the best traditions from both the civil law and the common law jurisdictions. You can tailor your proceedings to the needs and expectations of the parties. Depends entirely. The parties are in the driving seat along with the arbitral tribunal if the parties do not agree. The proceedings tend to be more front-loaded civil-style proceedings which follow a strict procedural timetable. So right at the outset, you have a procedural timetable that is set. The tribunal sticks to it, the party sticks to it, unless there's some exceptional circumstances that arise. So you also have a good idea of when your proceedings will end, when your arbitration is scheduled to end. Contrary to sometimes what I've seen happen in India, there are no phases or, let's have an award on this part. I mean, of course, proceedings can be bifurcated, but again, then the bifurcations are very clearly set out. But you tend to have one final hearing, evidentiary hearing on the entire proceedings, following which within 3 or 6 months, depending on the arbitral rules, the tribunal will render an award. So it's not a long, drawn out process and can, extend over years without any clear end in sight. We do have, of course, witness statements and cross-examination, which comes from a bit more from the common law jurisdiction side, but in Switzerland, it tends to be a bit limited and much shorter. The rule tends to be, at least the way the practice, I don't know if I could say the rule, but the practice tends to be reliance more on written documentation supplemented by witness evidence if needed. There is document production as well. Of course, that's built into the arbitration timetable, but it's also not the extensive US style discovery of any and all documents, even remotely relating to something. Swiss arbitrators and arbitrations in Switzerland generally tend to follow the IBA guidelines, and you really have to show the relevance and the materiality of the documents you are requesting. They have to be limited, they have to be well defined, they have to be a subset or a category of documents as well if you want to define it. So there are limitations on the document process, document request process as well that apply. Switzerland is, as very mediation and negotiation friendly. So mediation is encouraged. It's encouraged in the Swiss court system for sure, and I think that has also infiltrated the arbitration system a bit. At any point in time, if the parties so wish, they can stop the arbitration proceedings, even ask the arbitral tribunal to conduct mediation proceedings and try and amicably settle their dispute. And if that fails, then get back into arbitration. So it's a very flexible process between mediation and arbitration. And generally, as I said, this tends to be short evidentiary hearings focused really on the issues that are still in dispute after the entire written phase of the arbitration has concluded. The idea is really to present evidence on what could not have been presented with written documentation, or to clarify written documentation if that is needed. So just to go to the next slide, just to give you of institutional rules that we have. Sorry, no, the slide before it was on the Swiss rules of international arbitration. We have. So can we move to the previous slide, please? Thank you so much. So we have institutional rules in Switzerland. The ICC is present for sure. We have ICC Switzerland. We also have the Swiss rules of international arbitration of the Swiss Arbitration Center, which are sort of the homegrown. It's a homegrown institution with the homegrown arbitration rules. Again, very competitive rules for cost efficiency, very efficient, very light touched. A light administration of the arbitration proceedings, so the institution is there, but again does not intervene per se in the arbitration proceedings. Extremely cost efficient. There's a supervision of the International Arbitration Court, which is the court of the Swiss Arbitration Center, that supervises the proceedings and intervenes if needed. For example, if the parties fail to appoint their arbitrators or the arbitral tribunal, etc. But otherwise, no intervention. And the Swiss arbitration rules also have the most common features that you see in other rules, sort of expedited procedures with an opt-out option if needed. Ex parte interim relief, which now would go before an emergency arbitrator if needed. The Swiss arbitration rules generally, and arbitration in Switzerland generally, tend to follow the principle of the losers pay. So if you win in your arbitration, you tend to recover your costs, both your legal fees and all the institutional fees. It's the loser that pays for the arbitration. Of course, this principle is applied, depending on the circumstances of the case. Sometimes the tribunal may split it if they deem that the circumstances so require, or if the procedural conduct of one of the parties was not optimal or in bad faith, then they could take these considerations into account when determining the costs of the arbitration. And I mentioned earlier as well, very easy to combine with other ADR methods such as mediation, etc. My last a few words that I wanted to spend on was on Swiss contract law, which we very often see combined with Swiss arbitration. So you would have seat in Switzerland, Swiss applicable law, very, very common in a lot of the international contracts that we see, particularly, trading contracts, banking contracts. Swiss law is a very pragmatic law, commercial law, if I can say so. It is, you find, so all the codes or Swiss codes, so whether it's the civil code, the code of obligations, which is mostly the one applicable, all of them are found in English on the internet. The official translations are, sorry, I should not say official translations. There are translations. English is not an official language of the Swiss Confederation. There are only 4 official languages, but all these codes are translated in their entirety on the internet, and that makes Swiss law extremely accessible also to sort of non-German or French or Italian speakers. A very pragmatic law, very commercially minded law. The Swiss law solutions generally tend to, again, favor commercial reasonableness, at least in commercial international arbitration disputes, like we see. So, in my experience, not always, but very often, Swiss law is chosen as the lex speciae, particularly if there is a connection to Switzerland or the seat of the arbitration is in Switzerland. And then last, I just wanted to speak quickly about other aspects. Sorry, if we just go to the next slide. Can we move to the next slide? Yeah, the next slide. Okay. Yeah, so, a summary of a bit of a summary of all the things that I've spoken about, a bit like the Swiss Nami knife, the multi-purpose tool. You have a politically stable and a neutral jurisdiction like Switzerland that combines efficiently civil law and common law practices and tendencies. You have a very pragmatic contract law that could be applicable to your case. And at the same time, you have what we call Swiss Arbitration Hub, the Swiss Arbitration, the website, swissarbitration.org, where you find, in a nutshell, everything that I have spoken about and everything related to arbitration in Switzerland. This is the website of the Swiss Arbitration Center and the ASA, the Association Suisse de l'Arbitrage. If you visit this website, you'll find everything about the law and the rules, the arbitration rules, etc., that I just spoke about, but also far more practical information about, conducting hearings in Switzerland, any information we need about how to find venues or court reporters. I mean, information from that to information about how arbitration proceedings are conducted in Switzerland. So this website is really sort of a one-stop shop for anything that you would need relating to arbitration in Switzerland. Under the ASA, the Swiss Arbitration Center, there are also 2 very, very interesting tools that I just want to mention over here since we are talking about arbitration in Switzerland. That is the Tribunal Secretary platform and the Toolbox. If you go to the website, you will see that the arbitration toolbox is how should I say, it's a flow chart that summarizes the entire arbitration proceedings from start to finish and gives you practical information on every step of the arbitration that you could need. It's a practical tool that has to be interacted with, so I encourage a lot of you to go and see it. It's on the website of the Swiss Arbitration Center. And likewise, the Tribunal Secretary platform is a platform that has been recently launched for independent tribunal secretaries that want to connect with independent or other arbitrators or arbitrators that are looking for tribunal secretaries that have experience, etc. You can put your profile up there, and it's a connecting platform for arbitrators and tribunal secretaries. And the only last thing I would mention, and I request, since I'm running out of time a bit, I would request you to just go to slide 14, which is about the Asia chapter of Swiss arbitration, because that might interest a lot of people on this call. These are the things I just mentioned. Yeah, I just wanted to briefly mention the Asia chapter of the Swiss Arbitration Association. It's always very interested in dialogue and collaboration and meeting with parties in Asia. So please free to reach out to any of the people mentioned on the slide or myself, and we're happy to discuss further. And that brings me to the end of my presentation. I think I'm just in time. So thank you very much for your attention. Thank you very much to the organizers for giving me this platform to speak about arbitration in Switzerland. I hope I've given you a sufficient overview, and I'm happy to take any questions that there may be.
Yeah, thank you, Dilber.
Can we just put the last slide on so it's
Yes, yes.
take it off? Yeah, that's fine. That's good.
Thank you, Dilber, for insight on the success story, what we have. Anyway, the slide is shared. Yes, just the earlier slide. Yeah, Dilber, it is the final slide is shared. I think it's a very unique culture what we have to take from the Swiss arbitration. As rightly highlighted, it is a tool which every practitioners have to seriously take upon